Land Acquisition Act and its effect. The Land Acquisition Act. The Land Acquisition Act was brought to effect the pre-existing fundamental right to livelihood of citizens affected by land acquisitions. It ensures that livelihood will not be taken away unless it is in the public interest and the affected citizens are given rehabilitation. First, an important clarification. The new law does not apply to privately negotiated land purchases except rehabilitation and resettlement provisions that will apply to large purchases for which thresholds are to be determined by state governments. The new law's ambit is limited to situations where the government is acquiring land for a public purpose to be used by itself or by a private entity. Consent. No consent is needed for government projects, but 70% of landowners must consent for public-private partnership projects and 80% for private projects. In the case of a piece of property, a social impact assessment is needed unless and until there is a pressing need. Environmental impact assessment is required if the project is for irrigation. Along with a recent report by Center for Policy Research in New Delhi, there are over 1,200 land-related laws in India with around 150 federal laws in just 8 states of the country. Safeguards. State governments must appoint a dispute resolution chairman who must be a federal judge or a lawyer who has practiced for at least 7 years. The Act also establishes a land acquisition, rehabilitation and resettlement authority to expedite conflicts. Return of property. If the project does not get underway within 5 years, the land purchased under the Act must be returned to its original owner or even the land bank. Irrigated multi-crop property. If the land in question is irrigated multi-cropped, the state government has to set a cap on how much can be bought. Constraints. The Central Act of 2013 was enacted to add effects to citizens' pre-existing constitutional right to subsistence. It guarantees that one's life will not be taken away unless and until those conditions are met. It serves the public interest as shown by social impact assessments. Care is given to those who have been harmed. Citizens' constitutional rights will be eroded if changes are made without taking into account the factors above. Compensation. Owners of acquired property would be compensated 4 times the market value in rural areas and half the market value in urban areas. The legislation also allows businesses to make a one-time payment to artisans and small traders affected even though they do not own any property. What are the features of new law that makes it a win-win situation? First, the new law calls for a social impact assessment to be undertaken before the land is acquired. Instead of being an additional bureaucratic layer, the SIA can proactively address key issues that repeatedly stall acquisitions today. Second, the new law establishes specific deadlines for various phases of the land acquisition process, ensuring that it does not go on indefinitely and can be done quickly. There are no timelines in the existing law. Third, in order to avoid acquisition costs from spiraling out of control, the concept of market value has been changed to ensure that the price paid in one acquisition does not serve as basis for calculating compensation in subsequent acquisitions. Social Impact Assessment. An SIA survey, a preliminary notice indicating the intent to acquire, a declaration of purchase and compensation due by a specific date are all part of land acquisition process. The SIA requires the government to obtain the approval of the affected artisans, labourers, sharecroppers and the project would impact tenant farmers among others whose self-sustaining livelihoods. The social impact assessment slows down and increases the cost of land acquisition. State land policies. The lengthy process and high costs of 2013 Act have caused concern among capitalists and businesses. Some states' governments have developed their own alternative land regulations to make land acquisition easier for developers, leading to a shortage of clarification in federal land acquisition provision. Gujarat, Madhya Pradesh, Uttar Pradesh, Telangana, Andhra Pradesh, Rajasthan, Haryana, Delhi, Bihar, and Maharashtra are the states in question. Several ventures in Gujarat and Telangana have been exempted from SIA and landowner consent requirements. Affordable housing, industrial corridor, public safety, defense, rural infrastructure, and other PPP initiatives. PPP projects in Maharashtra are excluded from the SIA and consent clauses fully. On the other hand, Telangana, Uttar Pradesh, and Andhra Pradesh have all shortened the notice period for public consultation under the SIA from 3 weeks to 1 week. For businesses looking to invest in India, land acquisition is a significant stumbling block. Land acquisition is a major bottleneck for companies looking to invest in India. In India, where land is a crucial factor, the difficulty of obtaining land in a reasonable amount of time has tended to deter investments in manufacturing and the construction of industrial corridors and transportation infrastructure. the country's numerous land laws are poorly established and often have resulted in disputes. However, state government, business enterprises, and investors have identified numerous procedural difficulties in acquiring land for significant national projects since the law's enactment. Land issues remain a key deterrent for industry and prosperity in India. The first criteria for investment is the availability of land. In India, however, it is still mired in complexities. Land ownership records are spotty at best, and the process of acquiring land is lengthy. Since the law enactment, the state government and investors have reported many procedural difficulties in the acquisition of land required for important national projects. According to a recent investment bank analyst survey, land costs account for less than 5% of capital expenditure in industries such as power, steel, automobile, and refineries, and the new law would have no significant impact on the internal rate of return of these ventures. Private entities and scheduled caste, scheduled tribe. All acquisitions for private purpose require companies to provide rehabilitation and resettlement to the people affected by acquisition. Companies must pay 1/3 of the project's compensation to scheduled caste and scheduled tribe owners before the land acquisition process begins, and the remainder after the process is completed. In 2013, the UPA government passed the landmark right to fair compensation and transparency in land acquisition. Rehabilitation and Resettlement Act to loosen restrictions on projects in 5 main investment areas, namely security and defense development, rural infrastructure, industrial corridors, and social infrastructure projects including private-public partnerships. Despite government measures at state level, land acquisition remains a legal issue. The Supreme Court of India recently issued notices to Gujarat, Andhra Pradesh, Telangana, Jharkhand, and Tamil Nadu requesting that they amend their respective land acquisition laws and dilute the provisions of original 2013 Act. A court trial like this threatens to worsen problems for industries and investors already beset by India's complicated legal processes for acquiring property, encroachments, land disputes, and political uncertainty, all of which contributes to project delays, cost overruns, and market uncertainty. By encouraging governments to be judicious about amount of land they acquire for each project, this law will help ensure more productive land use, allowing India's limited land resources to be better used for long-term industrialization and growth. There is no doubt that a lot of further work is needed for the law to be worked as described. The SIA process, which has already begun, will need to be more detailed and streamlined. Many state land records which are poorly maintained in many states would need to be revised and modernized. To ensure effective and timely implementation, the states will need to establish clear, consistent protocols. This topic is also closely related to the issue of how to balance growth in agriculture with growth in other sectors of business world. Our Land Acquisition Act has brought development to this country with proper compensation to landowners. While our country is developing, we should bring more acts like this which will create more surplus. But it's almost a good sign that in our rakish democracy, no one seems to be fully satisfied with the new law. The previous land acquisition had a lot of problems, while this new law has brought equality and more sense to public. Each farmer can adopt its own comfortable lease term. We achieve more productive land use, ensuring the best possible use of India's limited land resources for long-term industrialization and growth. Thank you.